Hello and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Today, we're zeroing in on Nevada Asset Protection Trust. It's a powerful tool for high net worth investors looking to shield their assets in an increasingly litigious world. Our topic, the three questions high net worth investors should ask about Nevada Asset Protection Trust. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. As we've discussed on previous episodes, asset protection is more than just insurance. It's about proactive planning to preserve wealth against unforeseen risks like lawsuits or creditors. For high net worth investors, Nevada Asset Protection Trust stand out due to the state's robust legal framework, no state income tax on trust assets, and enhanced privacy features. These trusts attract investors from across the United States because they offer flexibility and irrevocable structures while maintaining some control for the grantor. But with great benefits, as always, come nuances. And today we're going to tackle the three questions high net worth investors should ask about Nevada Asset Protection Trust. Joining us is Haneen Kutub. Haneen is a founding and managing partner at the law offices of Petrovitch and Kutub in beautiful Fort Lauderdale, Florida, where she specializes in estate planning and probate. Haneen, you made it onto the podcast. Great to have you here today.
Thank you for having me, Wayne.
It's going to be fun today. This is, I think, the first time you've ever been on a podcast, and it's not going to be the last.
Okay, so I'm excited.
it's going to be great. So before we get into the questions, why don't you share a little bit about what inspired you to focus on estate planning in general and in helping high net worth clients, build these strategies that you work on? What happened that made estate planning become sort of your jam?
Sure. So just to give you a little bit of background about me, I started my law career doing bankruptcy law, actually. And that was the sole area that I focused on. So I did a lot of Chapter 7, Chapter 13, Chapter 11 bankruptcies for individuals and companies and corporations. So I was in that world. So I got to see the other side of it where the creditors had already come into play and kind of, started seizing assets and getting judgments and attaching things. And then the individuals or the companies were left with no other option than to file for bankruptcy. So within that kind of spectrum, I started thinking, well, it really didn't have to be this way. There were strategies, things that this client or this company could have done not to wind up here that may have helped them. And that got me into thinking, what could they have done? What would have been a better plan? How could they have avoided this or at least mitigated some of the, consequences that resulted? So that's really what kind of propelled my interest into the area of estate planning and asset protection.
So just as a quick recap on asset protection, to get everybody up to speed, and this is my interpretation. So as asset protection really is about layering defenses to keep hard-earned wealth out of reach from potential claims. So if I assume I'm pretty accurate there. So from your perspective, what makes Nevada Asset Protection Trust, or NAPTs, or NAPs, if you will, particularly attractive for high net worth investors around the United States? Is it Nevada's state laws? Is it the no tax, no state tax, or is it the privacy statute? What is it that makes them so appealing?
Yeah, so it's actually all of those things, Wayne. So Nevada is a very debtor-friendly state. So in terms of what makes it appealing and what makes Nevada Asset Protection Trust specifically appealing is a few things. So one of them is the relatively short statute of limitations for the transfers to the trust, which is 2 years in Nevada compared to the 4 years or longer in some of the other states that allow these types of trusts. Number two is definitely the fact that there are no exception creditors, which goes to the privacy aspect of it. So for some states, they will allow certain types of creditors to break through that trust, which would include things like claims for child support or alimony or tort victims. So they're basically given a free pass, an exception to say, hey, this trust won't work for that. But Nevada doesn't have any exception creditors, which means that it's basically protected against those specific types of creditors in addition to all the other ones. And of course, yes, there are income tax benefits because Nevada does not have state income tax like other states.
So I did some research in advance of today's Zoom of our call today of our podcast, and there's this clause in trust documents called a decanting provision. Can you explain what that is, first of all, and what role does a decanting provision play in maximizing a Nevada Asset Protection Trust effectiveness? There is a correlation there.
Yes, definitely. So let me start by saying there are two main types of trusts. There are revocable trusts and irrevocable trusts. And the kind of trust that's going to give you the protection that you want is an irrevocable trust. So what that means is typically with those types of trusts, the word says it all. You cannot make changes to the trust. Whereas a revocable trust, you can kind of go in there and change the whole thing, take out terms, put in terms, do whatever you want. Irrevocable means that once you set it up and you have the terms and provisions in there, you can't change them. However, states like Nevada allow for decanting. Decanting is the way to basically allow the trustee to pour the assets of that one irrevocable trust into a new irrevocable trust with better or preferential terms. And that allows for a lot of flexibility. And that can be anything from like changing the jurisdiction to updating the provisions regarding tax efficiency to putting in more contingencies about beneficial interests. There's so many different things you can do through the decanting and also through use of the trust protector clause that Nevada also allows, which can help you add and remove beneficiaries, which is something you typically cannot do in an irrevocable trust. So all of these things together make it very flexible to have the trust, to make the changes when necessary, and not jeopardize the efficacy of the trust itself.
So I'm going to give you a layperson question here, just for the fun of it all. So in this decanting provision, you talked about moving assets from one irrevocable trust to a second irrevocable trust. Have you ever seen a situation where part of those assets were decanted, pardon the term, from irrevocable to revocable, or is it always irrevocable to irrevocable?
It's typically irrevocable to irrevocable. And let me explain why, because there was a reason that trust was set up as irrevocable. If there is no necessity for that anymore, meaning whether it's tax planning or asset protection, then there's no need for the trust to be irrevocable. But if you still have those needs, which is the purpose of the trust, then you're definitely going to be decanting into another irrevocable trust.
Okay. I had to ask. It was just too tempting, right up there on a T for me. Okay, so we're going to be discussing the three questions high net worth investors should ask about Nevada Asset Protections Trust. So, Haneen, why wait? Let's get started with our three questions, and we'll get to question number one. Here we go. I'm in the process of finalizing the sale of my business, and I expect to net approximately $20 million. Given that I should have time to plan, what should I be thinking about? Haneen, take it away.
Okay. I mean, aside from the tax consequences, obviously, you should always be consulting with your business attorney about your exit strategy and what you're going to be doing with those funds tax-wise. But we're talking here about other types of planning. So, for example, if you know you're going to be netting a significant amount of money, and that money could be either taxed or exposed, you definitely want to start thinking about what kind of structures or entities you want to put into place before you get that money and where you want it allocated, whether that's going to be into entity structures like LLCs or corporations or trusts for the protection of the assets, for tax efficient growth, And then for distribution provisions within the trust about who and when and how the beneficiaries are going to have access to these monies if they're going to be getting them. So all of that should be thought about and put into place before you actually get the funds because the advantages sometimes are lost if you do it after.
So, would you be recommending establishing a Nevada Asset Protection Trust now for this individual, before the sale closes? And if that's the case, uh, would that provide any level of tax efficiency or creditor shielding for that windfall, like in the near term, or does that make sense?
Yes, certainly. So sometimes, as far as taxes go, Nevada is one of the states that does not have state income tax, as I previously mentioned, or state capital gains tax. So if you're thinking about um, ways to minimize that potential impact, especially if you live in a state that does have state income tax, state capital gains tax, you may want to think about how to structure things to place some of those assets into and some of these DApps are structured as NINGs. I don't know if you've ever heard of those, Wayne, but they're basically Nevada Incomplete Gift Non-Grantor Trusts. The acronym is NING. So it's basically a way so that you are taxed on those assets within the trust. Because if it's in the trust and that trust is established in a jurisdiction that does not have state income tax, there's definitely going to be more tax advantages, right? Than if you just sold it individually as yourself in a state that does have state income tax, right? So that's just maybe part of the tax planning that should happen within the overall planning strategy. But certainly, if you're worried about any potential outside attacks or claims on the money before you actually get it and are having the sale proceeds in your hands, you want to make sure that the transfer is going to happen into that asset protection trust so that you can start that statute of limitations period and you can get the money protected or the assets if you're going to be rolling it into another asset as quickly as possible. So that's very important, I
That's
would
a good
say.
idea. Okay. So today our topic is the three questions high net worth investors should ask about Nevada Asset Protection Trust. Joining us is Haneen Kutub. She is a founding and managing partner at the law offices of Petrovitch and Kutub in Fort Lauderdale, Florida. Haneen, great having you here. Thank you so much. Let's move on to question number two. My 18-year-old daughter graduated last summer, and to reward her for all of her hard work, we bought her a new car. Aside from purchasing umbrella insurance to protect ourselves in case she gets into an accident, is there anything else we should consider? Your thoughts?
Yes, absolutely. So I know it's a difficult and maybe not very popular thing to say, but it's really not beneficial for you to have that vehicle titled in your name as the parent with substantial assets with your young adult driving around in the vehicle. I'm sure you know, Wayne, how frequent car accidents are and
Yeah.
fender benders or worse or whatever. And you have these inexperienced young drivers driving around in a maybe nice vehicle and causing accidents potentially. Because the problem here is that they're going to go after the big fish, which is you, the owner of the vehicle. And that could potentially expose your assets to huge liability if there are injuries involved. So ideally, you wouldn't put it in their name, but I can understand how some parents may want to maintain control of the asset, especially if it's a new vehicle, a nice vehicle that they really don't feel comfortable titling in the name of their child. So one option I would recommend is perhaps holding it in an entity. And for added protection, that entity's interest can be owned by an asset protection trust so that it's a double layer of
So
protection.
you're thinking entity. I'm just going to put this out. Are you talking like an LLC entity? Like,
Yes, you can
that's
100% own a
interesting.
vehicle in an LLC.
Set up an
And
LLC for your child's car. Interesting.
I mean, it's definitely a good option because of the charging order protection. So you get basically getting double protection. You're getting charging order protection, and then you can have the interest owned by trust if you so choose. It's not obviously something each structure is customized to what the client feels comfortable with and what they feel like they need. But any way you slice it, if that car is just in your name or in your name and the child's name, you're exposed. And
So,
sometimes
go
umbrella
ahead.
insurance is not sufficient.
So, if we're gifting assets like new car, we'll say it's not just a 2008 Honda Accord here. We're talking a brand new, nice car.
Are you
Uh,
saying a 2008 Honda Accord is not a nice car?
no offense to anybody who owns a 2008 Honda Accord here. I was thinking something more like, maybe a new, uh, like a Tesla, all the bells and whistles. You're welcome, Elon, for the plug. But when you're gifting assets like this, how would one of these Nevada asset protection trusts help insulate the family wealth from these future liabilities? And again, it could be, student loans or other early career. Like, how does that work?
So basically, let's say the interest in whatever it is, whatever you gifted to that child, let's say it's
Right.
owned by this asset protection trust.
Correct.
The whole point of these trusts is that they are shielding what's inside them against the creditors of the beneficiaries. So in this instance, your child would be a beneficiary of the trust, but not an owner of the assets. So the actual owner is the asset protection trust. And the asset protection trust contains the provisions that say this beneficiary has no control over the disposition of this asset and does
Hmm.
not have a right to have it assigned to a creditor. So that creditor does not, if the trust doesn't authorize a creditor to have access to the assets, then it's a bar versus there is absolutely no bar when something is just in your name, even if you have not collected it yet.
So
And this is a very common misconception.
So this is a layering that we talked about earlier, just adding another. So it wouldn't be like you wouldn't go out and buy an umbrella policy or anything like that. You would still do that, but this just adds another layer of protection.
Correct.
Right. Okay, so let's get on to question number three, Henning. We were getting through these really nice and quickly here today. So question number three. I am planning to retire in the next 2 or 3 years. As a part of my retirement planning, I'm looking at relocating from California to Florida. That's not a first. Uh, how would this move affect my asset protection strategy? Haneen?
Okay. So one thing that people should know is that California is actually one of the states that is more creditor friendly, meaning that their laws tend to protect creditors more than the debtors, which is the people who are looking to protect their assets, which is your common everyday person. So, what that means is if you're going to move to a state like Florida that is actually debtor friendly, which is demonstrated by our super strong homestead protection laws and also our statutes and laws protecting retirements like IRAs, 401ks, pensions, then you're going to want to think about um, basically making it so that it is clear that you no longer consider California your domiciliary or resident state because you basically want to show that now, as a resident of Florida, you can take advantage of these very advantageous statutes and laws, in addition to planning for the assets that may not be protected by those statutes and laws. And the other side of it, Wayne, is that even when it comes to asset protection trusts, states like Florida have a much stronger position on them being valid and enforceable than like a state like California that might say, oh, well, we don't know, we don't feel comfortable with these or whatever their public policy says. So you definitely want to take a picture and look at all of your assets, when you're making this transition and see what you need to change because people are like, oh, I just left it over there in California. It's in an account and some kind of investment or whatever. But you want to make sure that any advantage you can take from the new state that you're transitioning to that is more friendly towards debtors and that does have more protective laws, that you're utilizing them and that you're covering all your assets with them. including creating something like an asset protection trust for those other assets.
So, as you talked about earlier, given the strong homestead protections, how does a layering, I guess I'll call it a layering of a Nevada asset protection trust complement a move like this, especially for non-real estate assets?
Yes, this is very important. Because of Florida's unique homestead law, you definitely want to consult with a Florida attorney like myself or any other Florida attorney about what you should not do with your homestead, because that could potentially jeopardize all the benefits and protections that you get from Florida. For the non-homestead real estate, we can absolutely plan to place those interests in, for example, an asset protection trust as well as personal property assets, which is like cash, stocks, investments, business interests, because none of those things are protected by any laws or statutes, even in Florida. So those are the assets that are going to be kind of, shall we say, exposed, that would need and require more planning, more structuring, more moving around, because they're not already afforded the protections under Florida law, like homestead and retirement.
I'm listening to you share all this, and all I can hear in the back of my mind are people saying, "Oh, this is all sounds really good," um, but what about the cost and maintenance of these? So I think for folks listening in or hearing about Nevada Asset Protection Trust, I think there are probably some misconceptions about all of that. So maybe you could just share a little bit about the setup costs, the maintenance, and how they can evaluate all of that to see if the benefits outweigh the cost of maintenance of these plans, of these trusts, pardon me.
Sure. Yeah, definitely, Wayne. So I think the most common misconception about these types of trusts is that they're difficult, complicated, and very expensive to set up. And I think some of those misconceptions stem from um, basically offshore asset protection trusts, which I'm sure you're familiar with, Wayne, that were very popular back in the day before there were more domestic options made available by these states. So what that means is back when, the only option was to set an asset protection trust up offshore outside of the US, those trusts till this day remain very expensive to set up and very expensive to maintain because they're in a completely different country. And not many people feel comfortable with that. Not many people feel super confident sending all of their money over to the Cayman Islands or Belize or wherever they're going to send it to. And yes, those trusts are expensive, complicated. You're dealing with a lot of rules and regulations about foreign trusts and, the money and all the disclosures and all the things that you have to do under federal law.
You're giving
So,
up control of your money. Let's be clear here.
yes. So that is the biggest and I'd say most common misconception, is that it's like that. Okay. But it's not. So these newer versions, these domestic asset protection trusts have been around since like the early 2000s. And still people don't know about them and don't know that they're an option. So they're very curious about them and are not really familiar with how they work. And they kind of correlate them to the offshore ones, which they're very, very different. They're actually much less complicated, very reasonable to set up in terms of setup fees, and very reasonable in maintenance. And the benefit and the protection that you get far exceeds and outweighs all of those things. And I think that if people were aware of that, they would utilize them more, because I think that they're very much underutilized in people's estate plans.
Hey, before we wrap up and get you out of here, Haneen, I just, one of my favorite lines is "Time passes and things change," right? So as you look ahead, how can you see federal laws evolving or the economy changing? How does any of that influence the appeal for Nevada Asset Protection Trust? And I think about this across, from Florida, north, the East Coast, or any part of the country. Is there any correlation there in terms of all of that, whether the laws are changing or how the economy changes? Does that, do you think, have any effect on people's appeal for these types of trusts?
Oh, I definitely think so, Wayne. So I'm sure you're aware that the tax laws for estates and inheritance basically changing effective
Yes.
January 1st, 2026. Previously, there was a fixed amount that you could leave and pass on to your heirs before it was subject to federal estate tax, which was taxed at a very high rate of 40%. But those laws had to continue to be, renewed because they would run out and sunset and whatnot. But effective the beginning of next year in January, it's going to be permanent, the exemption amount, the protected amount
It'll
at
be permanent
15
until the
million.
laws change again.
Yes, exactly. But it'll be 15 million per person adjusted for inflation going forward into the future. So that's 30 million per married couple that you can pass on to your beneficiaries without any tax. Federal tax, some states have state estate tax, but federally, and that's the biggest chunk that usually people are worried about. So when you think about that amount of money and you think about that there's between 40 and 60 million lawsuits filed annually in the US, which I'm not sure if you're aware of, but
40 to 60 million lawsuits are filed annually.
yes, in state and federal courts. And you start to think about, well, what am I more worried about here? If I don't think I'm ever going to hit that maximum threshold before I hit taxes, which was a huge concern in the past, but I still want to make sure that this substantial amount of wealth that I do have is shielded and protected because, like you said, very highly litigious society, and the
One
smallest thing.
fifth of the population potentially is being, well, I guess we'd see corporate entities too. So, but pretty high percentage of lawsuits happening in this country per capita.
Right. So I do think that's going to make a difference in how people plan for their estates and make these types of trusts more common and more, in demand.
Well, there's folks who are watching us live here, not live, but they're watching us on video here, and we've put your contact information right underneath your picture so everybody can see who you are and how to get a hold of you. But we got lots of folks listening on Apple, on Spotify. They can't see all of that. So for those folks who are listening, what is the best way for them to find and contact you, get a hold of you?
Thanks, Wayne. So the best way to contact me is definitely to reach out to me via phone or email. Our website is readily accessible. It's www.pklegalgroup.com. My phone number is 561-444. Sorry, 561-444.
0131.
Yes, I almost reversed it. 013.
Yeah, let's do it one more time. 561-444-0131.
561 561-444-0131.
You know what? I remember back in the day, I knew all of my clients' phone numbers. Now it is pointless. With the clicking of the phone now, you never remember phone numbers.
I know the number and then I reverse it sometimes in my head.
It's totally fine. It's totally fine. I want to thank you, Haneen. You've been a great guest today. You really educated and informed us on all about Nevada Asset Protection Trust. You were great. Haneen Kutub is a founding and managing partner at the law offices of Petrovitch and Kutub in beautiful Fort Lauderdale, Florida. Haneen, thank you very much. Thank you for making time for us. Appreciate it very much.
Thank you, Wayne.
I look forward to bringing you the 3 Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification of when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.